Alleged 8.7 billion money laundering. EFCC arraigns Malami, wife, son in Abuja court.
The Federal High Court in Maitama, Abuja, was thrown into stunned silence on Tuesday, December 30, 2025, as the Economic and Financial Crimes Commission, EFCC, docked Nigeria's immediate past Attorney General of the Federation and Minister of Justice, Abubakar Malami, SAN, alongside his wife, Hajia Bashir Asabe, and their son, Abubakar Abdulaziz Malami, over an alleged money laundering scheme involving a staggering 8.71 billion Nigerian nairas. Let's keep the news rolling, but before then, let's ask ourselves these questions. Why do people love committing crime? Why was Abubakar Abdulaziz Malami arraigned for 8.71 billion Nigerian nairas money laundering? What's the next action to be taken by the EFCC? All these questions will be answered here. Kindly like and subscribe to this channel for more updates like this. The high-profile arraignment, which sent shockwaves across legal, political, and public circles, unfolded before Justice Emeka White, marking a dramatic fall from grace for a man who once stood as the nation's chief law officer and custodian of justice. According to the EFCC, the defendants are facing a 16-count charge bordering on conspiracy, procuring, disguising, concealing, retaining, and laundering proceeds of unlawful activities, in violation of the Money Laundering, Prevention and Prohibition Act, 2022. The sheer magnitude of the alleged financial transactions and the involvement of close family members have sparked widespread outrage and deep public concern. At the commencement of proceedings, Prosecution Counsel, Ikil Ahionocho, SAN, informed the court that the matter was slated for arraignment and formally requested that the charges be read to the defendants for their pleas to be taken. My lord, this matter is for the arraignment of the defendants on a 16-count charge dated and filed on December 23, 2025. We respectfully pray that the charge be read and the pleas of the defendants taken, Ahionocho submitted. Defense Counsel, J.B. Daudu, SAN, raised no objection, prompting Justice Nwite to order the reading of the charges. One of the most disturbing allegations is contained in Count 1, which accuses Abubakar Malami, SAN, and his son of procuring Metropolitan Auto Tech Limited between July 2022 and June 2025 to conceal the illicit origin of 1.01 billion Nigerian nairas lodged in a sterling bank account, funds the prosecution insists they ought reasonably to have known were proceeds of unlawful activity. In Count 5, the EFCC alleges that Malami, his wife, and his son conspired in September 2024 to disguise the source of over 1.04 billion Nigerian nairas funneled through the Union Bank account of Mithaq Hotels Limited in Abuja over a 2-year period. The charge paints a troubling picture of coordinated financial maneuvering allegedly designed to mask illicit funds. Equally alarming is Count 6, which claims that Malami and his son indirectly took control of more than 1.36 billion Nigerian nairas paid through the savings account of Mithaq Hotels Limited between November 2022 and October 2025, despite allegedly knowing, or having reasonable grounds to suspect, that the funds were linked to unlawful activity. All three defendants pleaded not guilty to the charges, setting the stage for what is expected to be a closely watched legal battle. Following the pleas, Ahionocho informed the court that the prosecution was fully prepared to proceed to trial but disclosed that the defense had served a bail application only a day earlier, requesting time to study and respond to it. In a swift response, Daudu urged the court to grant bail orally, arguing that the alleged offenses were bailable and that the Administration of Criminal Justice Act, ACJA, does not mandate that bail applications must be made in writing. However, the prosecution strongly opposed the request, warning the court against granting what it described as a premature and procedurally flawed application. This is a court of record, Ahionocho argued. Submissions of counsel, no matter how eloquent, do not constitute evidence. Granting an oral application in a matter of this magnitude would amount to ambushing the prosecution. He further emphasized the public interest implications, noting that the charges involve complex financial networks and an alleged abuse of public trust by individuals who once occupied the highest levels of authority. The fact that the first defendant once held a powerful office does not entitle him to preferential treatment before the law, he stressed. In his ruling, Justice Nwite agreed that fairness demanded the prosecution be given adequate opportunity to respond to the bail application. He consequently ordered that all 3 defendants be remanded at the Kuch Correctional Center and adjourned the matter to January 2, 2026, for hearing of the bail application. The arraignment has ignited widespread debate and regret across the country, with many Nigerians expressing disbelief that a former Attorney General, once entrusted with defending the rule of law, could find himself at the center of such grave allegations. As the case unfolds, it stands as a sobering reminder of the far-reaching consequences of alleged financial misconduct and the enduring demand for accountability at the highest levels of power. Thank you for listening to this news, and ensure to subscribe, like and share our news update. Complement of the seasons. Do have a wonderful Christmas celebration and a prosperous New Year.